Parents and guardians of the 21 young people who died at Enyobeni Tavern in Scenery Park, this is in East London, this was in June this year, are unhappy about explanations on their deaths. Now, the latest toxicology report shows that the deaths are as a result of suffocation and that they were, quote-unquote, crushed due to overcrowding. Now, parents are calling for the owner of the tavern to be charged with murder. Joining me now to discuss the legal option for parents is the human rights lawyer, Richard Spoor. Richard, good morning to you and thank you very much for your time. I'm not sure if you have been monitoring this matter, but the latest coming out from government in the Eastern Cape is that, yes, the results, the toxicology results are out, but parents cannot be given these results in hand or in writing because the department says they are anticipating an inquest. How do you see this? What options do these parents have?
Well, it's completely unacceptable. The next of kin are entitled to see the post-mortem reports and the medical records relating to their children so that they can understand what has happened to them. The verbal reports that they have received are totally, unsatisfactory. To talk about suffocation doesn't tell us anything. The proper term is asphyxiation, and it can have a number of causes, including carbon monoxide poisoning. This suggestion was raised at one stage about an electrical generator in the tavern, which might explain things. It could also be a drugs or poison overdose. There was talk about ethanol in their blood, which may lead to asphyxiation, paralysis of the organs. And then you get something called compressive asphyxia, which can be caused by crushes and can be caused by overcrowding. But to reach those levels of overcrowding, you need crowd densities, substantial crowd densities of about 6 people per square meter. It's also very difficult to understand how we could have people dying of compressive asphyxia if the people who survived this event can't recall it or talk about it. We have had historically, there have been crushes like this where people have died as a result of crush asphyxia. But it's a panic, it's people confined to a space, there's a fire, something terrible happens, There's a stampede, people get crushed. The current explanation is no explanation at all. And the families have a right to that information, and they do not need to follow the prescripts of the Promotion of Access to Information Act to get that information. The law is very clear. If there is something that you're entitled to as of right, you do not need to go through the PIA process, which is a long process. The authority to whom you make your request has got up to 3 months to accept or refuse the request, and then there are complex appeals, and eventually you may even end up in court. The other explanation we've heard is there's an inquest coming. Well, inquest takes months. It's 5 years and the Lily Mine inquest is still ongoing. It's 5 years since that. And inquests typically follow criminal prosecutions. So if we're going to wait for an inquest to see this information, we have many, many months of waiting ahead of us.
What is normal practice?
It simply isn't acceptable.
I'm sorry to cut in there, Richard. What is normal practice? And the reason I'm asking that is that are the parents legally entitled to post-mortem results? And if, as you say, they are entitled to these results, do they have legal standing to actually take this to court?
They absolutely do. It's a fundamental right. I think it's associated with a constitutional right to dignity. If your child has died, you're entitled to know why he died and how he died and the cause of death, and to access the medical records pertaining to your child's death. There's no question that the state has no right to deny them access to these documents. But if they have, the families together could approach the High Court for an order compelling the government to release these records to them. They are entitled to them as of right.
You'll forgive my ignorance on this. So the department, on the one hand, says you are going to have to use the Promotion of Access to Information Act, the legal prescripts, to get this information, which, as you've explained, that could take 5 years. On the other hand, these children died at a private establishment. Why would the Department of Health need to worry about possibly being sued or any legal matters that will affect them?
Well, it makes no sense at all. I heard the spokesman this morning saying that, well, the owner of the tavern might sue them if they release this information to the parents. I mean, that is plainly nonsense. And there's another reason why government should be more forthcoming and explain what happened here. I mean, what happened at Enyobeni Tavern is tragic. 21 young people died. It can happen again. So we need to understand what caused this. You know, is it lack of policing, overcrowding, toxic alcohol, lack of compliance with the building regulations regarding the fire exits and exits generally from the premises? What was the cause of this? How are we going to prevent these kinds of tragedies if we don't know what gave rise to them? And frankly, it's inconceivable that the state doesn't know and understand more than 2 months after the event why this happened and how it happened. And as there's a public health interest in understanding what happened so that remedial steps can be taken and we can prevent a recurrence of this kind of tragedy.
So 2 final questions, but lumped up as one. So the parents, can they sue government for prolonging their suffering? Because all that they want is to know what took their children. And by government not releasing the results, they are prolonging that suffering. But then on the other hand, do parents have a claim against the tavern owner, civil claim, that is?
Yeah. Well, conceptually, there may well be claims against the authorities if they allowed and granted a liquor license to these premises that are clearly unsafe and were allowing, to the knowledge of the authorities and local people, young children, people under the age of 18 to go drinking there. There could be a claim about the licensing of these premises and the failure to enforce the law in relation to these premises. There could also be, there's certainly a claim against the tavern owner for doing this, but there could also be, as you note, some kind of claim for emotional distress and harm caused by the authorities' obstructive behavior. If the authorities are deliberately prolonging the family's agony by denying them access to information to which they're reasonably entitled, then conceptually, I'm not suggesting that there is a claim or substantive claim, but conceptually, there may be a claim for emotional distress and the kind of, the trauma that they are currently experiencing.
Richard Spoor, let me thank you very much for your time. He's a human rights lawyer giving us some perspective as to the legal options of these parents.